the purpose of this webinar is to give our audience a wider perspective on customs recordal in OAPI Western African countries. And this way help you understand the key challenges and opportunities in the region. It is quite important to highlight that OAPI is the sole governing body, IP governing body, for its 17 member states, and represents over 100 million people in West Africa. Customs recordal refers to the process of recording intellectual property rights with customs authorities. Through customs registration, authorities receive from right holders information about their intellectual property and can therefore monitor and, in case, block shipments contain counterfeit or infringing goods. This webinar shall, first of all, give you an overview of the OAPI mission and functioning. Then it will focus on the importance of customs recordals through the presentation of best practices, real-world examples, and success stories, of course. But let's move to business now. It is my utmost pleasure to introduce our first two speakers of today, two lawyers and experts about the matter. Please, everyone meet Marius Schneider, the founder and director of IP Vocate Africa, a law firm focusing on the protection and enforcement of IP rights in the African continent. Thank you for being with us today, Marius.
It's a pleasure. Thank you for having us.
Marius has a wide knowledge and expertise about IP in Africa. Among his clients are North American and European multinational companies who have turned to him to set up and enforce their IP strategy across the continent. It should also be noted that Marius co-authored the 2020 Oxford University Press publication, Enforcement of Intellectual Property Rights in Africa, this being the first book ever about IP rights enforcement covering all 54 African countries. Our second speaker, Nora Ho-Tu-Nam, is a lawyer from IP Vocate Africa as well, Marius's law firm, and is an expert in anti-counterfeiting matters in the continent. Welcome, Nora.
Thank you, Alberto.
Nora has an in-depth knowledge of law and practice of intellectual property rights enforcement, mainly thanks to her working experience in countries such as South Africa and the Gambia. Without further ado, Nora, Marius, the floor is yours.
Thank you very much, Alberto, for this introduction. And so if you can bring up the slides, please. So we've been talking today about IP enforcement through customs, through border measures, or also customs enforcement of intellectual property rights, as it's also called. So, Alberto, you have already summarized it in 2 words. How does it work? Customs have the authority either on their own initiative or upon an application of a right holder to detain goods at the border in order to allow the right holder to examine these goods, and if the right holder deems them to be counterfeit or infringing, indeed to initiate appropriate court proceedings so that there is a decision on the infringement by an official court, by an official instance that's given. So we'll look at how these border measures work in the area of the OAPI. The OAPI is, we'll go into detail there again later on, but the OAPI is 17 essentially Francophone West African countries that are part of this unitary IP system. Nora will explain it in more detail. So before we talk about how this works in practice, I think we need to quickly understand what is the problem of actually counterfeiting and piracy. Well, counterfeiting and piracy, this everybody knows here, is actually IP theft. And this IP theft does deprive companies of their investments in research and development, their investment also in creativity. So the first victim of this IP theft are indeed companies. But there are also other victims because counterfeiting is a danger for the consumer, and especially so in the African context. In the African context, the statistics teach us that there's more than 100,000 victims of counterfeit or falsified medicines, a lot of anti-malaria medicine and the like. So, in Africa, counterfeiting does actually kill consumers. And in our everyday practice, we have seen this. I mean, we have had cases of counterfeit snake bite antivenom, which does not contain any antidote. So, this is just an example. So you're bitten by a snake, you get the counterfeit snake bite antivenom, and it doesn't actually help you because it doesn't contain the antidote, and the patient dies. So, we have seen counterfeit cancer treatments and the like. So really, and spare parts, and you can continue this list forever. But in Africa, in the African continent, more than anywhere else, counterfeiting actually kills. That's something to retain here. Also, counterfeiting is a threat for the economy. Why? It actually deprives the state coffers of income. So normally the state perceives taxes on products that are legitimately sold on the market. Well, this is not necessarily, and most of the time not at all, the case for counterfeit products which are sold outside of the official legitimate trade channels. The same, employment, the counterfeiting deprives employees from work and also social welfare, because when you employ an employee in Mauritius, anywhere else, you need to pay social welfare. And well, most of the counterfeiters run, moonshine production, and so deprive the state first of the social welfare. And last but not least, that way, counterfeiting creates an unhealthy economic environment, because it's an environment that's infested by crime and other illegal activities. So if you don't pay attention, very quickly the situation gets out of control and gets a little bit like a pool of sharks. That's why, coming from an island, we wanted to illustrate this with a pool of shark. Nora, over to you. What's the advantages of customs recordals?
Yes, so thank you, Marius. So before I talk about the advantages of customs recordal, I just want to highlight why is it important to have a customs recordal and why customs is so important. So how do counterfeit goods arrive on the market? So you could maybe have domestic manufacturing, which is often not the case in a lot of African countries due to a more limited manufacturing capacity. So you could have the counterfeit goods that are produced locally and sold locally. Or you could have, and that's very often the case, the counterfeit goods are imported into the country, or even various parts of the counterfeited goods are imported in the country and then assembled in the geographical area where the goods are being sold. And in the last two cases, you can see very clearly why customs and customs recordal, why customs would be the first line of defense in preventing those counterfeit goods from entering the domestic market. Through customs, you can best stop the inflow and outflow of counterfeit goods within the borders, in the borders in the country. So many countries have therefore set up customs recordal, which, as Marius explained quickly before, is a procedure that allows right owners to request custom authorities to monitor imports bearing infringing or counterfeit intellectual property rights. So this system, so we're calling it customs recordal, but maybe in your country, it's called something different. In Mauritius, it's called border application. In other countries, it's called custom watch or custom supervision. But really the gist of the matter is that customs is monitoring imports or exports in some cases to ensure that there are no counterfeit goods that come inside the market, and that the interests of the right owners are therefore safeguarded against the counterfeit goods. So there are various advantages to the customs recordal. The first is that you have an early detection system that prevents the entry of counterfeits on the market. So the domestic market remains free of counterfeits. It's a cost-effective protection. So if you're acting against imports, you're more likely, therefore, to be falling on big, larger shipments. And that's usually more cost-effective going against one importer with a large shipment rather than going against smaller sellers of maybe a few products. Of course, it is possible to go against the smaller sellers, but going against the importer, really, it's more cost-effective for the right owner. And also, finally, the mere presence of a customs recordal can act as a deterrent to potential counterfeiters. The counterfeiters, they know that the goods are likely to be intercepted and seized, and therefore they are unlikely to import goods bearing that particular trademark in the country. So in Africa, Alberto mentioned the book that Maurice wrote, and while we're doing research on the book, we've noticed that there were a lot of African states that had in place laws that provide for customs watch, customs surveillance at the border, but very few had actually the regulations or the mechanism in place that would allow customs to act effectively. So we have put together a small slide of the African country, of the African map, African continent, and it kind of just shows in red, you see countries with formal customs recordal, and you see there are not so many of them out of the 54 African countries, mostly North African countries, and then South Africa, Kenya, and Mauritius. So in those countries, you've got a very good formal system in place. It's very easy. You know what you're supposed to do, which documents you are to provide, to whom you must write, who you must contact, etc. So it's very structured. But in other countries, they don't have such a structured system. But if you notify customs that there is an issue, customs will act. And you see there are a little bit more countries that do work on this kind of notification of rights. But in practice, there are even more countries that have in their customs code, or maybe in their IP legislation or their copyright legislation, a provision providing for customs to act at the borders against infringing goods.
Yeah, exactly. So, and we're going to see, if you go one slide back, Nora, one second, we're going to see in practice that OAPI countries have in their laws a provision to apply for a customs recorder. But in practice, it is not, we're going to see that, it's not 100% sure how this works and how effective this works. Thank you very much. So I would like to talk about a delicate subject, which is actually corruption. So maybe I want to start to just say that in Europe and North America, customs is considered the best ally when it comes to IP enforcement. Whenever our clients come to us and say, what can we do? You know, we found these infringing goods. What can we do? Well, the first thing we tell them is to approach the customs authorities for the obvious reasons that Nora has already explained here. So in Europe, customs is perceived as the #1 ally when it comes to enforcement. When I'm talking to my African clients, they are much more reticent. And why are they so much more reticent? Well, it's very easy because unfortunately, and it's not me who's saying this here, but it's statistics which we've picked out and which we published in the book, and we give reference in the presentation here. Statistics show that unfortunately in Africa, very often customs are considered as corrupt administration. So, for example, 17% of firms in sub-Saharan Africa cited customs as one of the most serious constraints to business and investment and one of the most corrupt government agencies. Cameroon, the National Anti-Corruption Commission ranked Cameroon Customs as one of the most corrupt agency in the country between 2010 and 2015. And even worse, in the Central African Republic, customs was considered by the own government to be so corrupt that the structure as such has been dissolved completely. So customs has been abolished completely in the Central African Republic in 2016, only in 2017 replaced by a new administration, entirely new administration, but which still does not control the entirety of the borders. Also, you have to understand, that in Africa, not all the borders are fenced, like some would like it to have fenced borders. Well, in Africa, that's not at all the case. Most borders are actually green borders that are very, open, and you can just cross the border from one country to another. So that's an additional hurdle. So right holders generally are reticent before approaching customs with the request to assist with customs enforcement of IP rights, because they fear to, get in this corruption mechanisms, entangled into this. So, that's a reality. So, meaning that, it's not as efficient as it should. Now, we know that there is a lot of counterfeit products going through African borders. And how do we know that? Well, because these products are actually on the market. And as I said already, counterfeit medicine, for example, kills in Africa. But we also know from highly mediatized actions that taken by the World Customs Organization or by experts from the EU, North America, that, there is a lot of counterfeiting going on, because what happens every now and then, the World Customs Organization, or as I say, the EU or North America come and send some experts to do actions against counterfeiting at the border, train the local authorities, and they have huge successes. So there's the Angaea actions, there's other actions like that. I take some pictures here from the website of the World Customs Organization to just illustrate that. So whenever, the international experts, World Customs Organization and the like are there, there's huge successes. And whenever they leave, this activity of customs enforcement, let's say, is taken up a little bit less enthusiastically in the African countries. So this is also something that is a little bit sad, and we sincerely hope that with the laws that are changing now, that customs will take more action and also continue these efforts once the international experts have left the country. So, this is something that is to be hoped. And it's also to be hoped that right holders do increasingly trust the customs authority and work with them hand in hand. And that is something that we need to build up, and it will take some time, but I'm quite convinced that, with the efforts that the African countries are now doing with new legislation and with the efforts like the Africa IP or the SME Helpdesk for Africa, that we will certainly reach some results. And so now let's just jump into the situation in the OAPI and see how it works there, please.
Okay, so we are going to be focusing on the OAPI. The OAPI, as was mentioned before by Alberto, is an intellectual property organization that is in charge of protecting in a uniform manner intellectual property rights in all its member states. So currently there are 17 member states. You can see the member states on the country. So those are mostly Francophone West African states and Comoros as well from East Africa. So the OAPI was created by the Accord de Bangui. So the Accord de Bangui was itself adopted on 2 March 1977. So what do I mean by it's in charge of protecting in a uniform manner IPR? What it means is that it is directly applicable. The Accord de Bangui, the provisions of the Accord, is directly applicable in the sense that they are the laws of the member states regarding intellectual property rights. The only exception would be for copyright. So the annex on copyright in the Accord de Bangui is a minimum requirement. So it provides for minimum protection that all member states must afford to copyright. Member states are, however, then free to provide for greater protection in their own country. So this is specifically for copyright, but for other rights such as trademarks or patents, the annexes in the Accord de Bangui are the laws in the country, in the member states. We're talking of a unitary system. It's a unitary system that is, if you apply for a trademark, for registration of a trademark at the OAPI, that means you're applying for a registration in all 17 countries of the OAPI at the same time. And that applies to trademarks, but also to patents, to geographical indication, to industrial designs, and much, much more. So why have we decided to speak about customs recordal in the OAPI? It's because very recently there's been amendment to the Accord de Bangui, and customs recordal has been introduced in the Accord de Bangui. So we decided to focus our presentation on trademarks because often it's a right most of concern for right holders with regard to customs recordal. But as you will see through the rest of the presentation, customs recordal in the OAPI is not meant only for trademarks, but there are other rights which are at play as well.
Yes, and before we dive into actually the OAPI Accord de Bangui, we have to look at the overarching legal regime, and that is the so-called Agreement on Trade-Related Aspects of Intellectual Property Rights, so the famous TRIPS agreement. You will probably remember, those of you who are around for a little bit longer, like me, there were the GATT negotiations, and the GATT negotiations, they ended in the 1990s into the creation of the World Trade Organization, and all the members of the World Trade Organization need to sign up for this TRIPS agreement, which entered into force on the 1st of January 1995, and is concerned, as the name says, with intellectual property, and it sets certain minimum standards for the protection of intellectual property rights for all World Trade Organization members. So it's really very interesting, this piece of legislation, because it was clear to the negotiators of the GATT and then the World Trade Organization that in order to do commerce, there need to be some minimum rules for things like intellectual property, and these have been laid down in this TRIPS agreement. Now, this agreement is now binding on all members of the World Trade Organization, meaning that all OAPI member countries are members also of the World Trade Organization, and so in principle, all of them need to apply the TRIPS agreement. Now, it's important to note, and that's what we put on this slide here, there is an exception for the least developed countries, and that in the OAPI is Benin, Burkina Faso, Chad, the Comoros, Guinea-Bissau, Mali, Mauritania, Niger, Senegal, and Togo, and they have until 2034 to apply the TRIPS agreement. But you will see that in relation to customs enforcement, they have decided to already apply something that is very conform to TRIPS already now, because as we will explain here, customs enforcement is now available since the Accord de Bangui. Now, this agreement provides for certain minimum standards when it comes to border measures, so customs enforcement. We will not go into the details. For those of you who want to do some further reading, these are the articles 50 to 60 in the TRIPS agreement.
Okay. So as I mentioned before, the Accord de Bangui, the Bangui Agreement, relates to a numbers of intellectual property rights that are provided for in the various annexes to the agreement. That means that there's an agreement, and then the agreement is accompanied by annexes, each annex, being focused on a particular right. So there have been amendments to the Bangui agreement and the annexes, and now customs recordal is provided for. So it is provided for trademarks, patents, utility models, industrial designs, literary and artistic property, and plant varieties. Commercial names, geographical indication, topographies of integrated circuits have, however, been excluded. There have been no amendment, no addition to the annexes with regard to border measures, and therefore those IPRs are excluded from the measures. So since the annexes take the place of law in the member state, because as I said, it's a uniform right. The Bangui Agreement is the law, the annexes are the law, the Bangui Agreement is the law, then the provisions on the border measures, as are provided for in the relevant annexes, are directly applicable in the member states. We will be looking at the trademark are the articles for trademarks and customs recordal, and you will see that simply saying directly applicable, knowing that something is directly applicable, does not mean that customs will be able to apply those measures without further assistance from the government, from the legislature in their countries. So one of the most important parts of the article we're going to be focusing on is Article 66, and that's concerned the request for the measures. So what it states is that customs authorities may, at the written request of the proprietor, the owner of a registered trademark, or the beneficiary of an exclusive right of exploitation, together with substantiated evidence, detain in the course of its inspections the goods which it suspects to be counterfeits. So that's a long article that we propose to now break into pieces with you to know what is possible and what is not possible, and what is still remains a gray area in terms of customs recordal. So when can customs act? So we've seen in the article that we've just that I've just read out, that the article talk of customs detaining goods in the course of its inspection. So this means that the powers of customs to act will be in the course of its inspections. So does this mean importation? Does this mean exportation? Does it mean transit? That's not made further clear in the Code of Bangui, in the annex. So what we believe is that this reference to customs in the course of its inspections, one should then refer to the national customs legislation to see what activities fall in the course of inspections by customs. Does importation fall within the powers, the actions over which customs have a right of inspection? That will likely be yes in all countries. With regard to exportation and transit, not all countries have the same types of laws and rules with regard to the powers of customs over goods in transit or over goods being exported. And therefore, we believe that it will be relevant here to look at the domestic, maybe the customs code or other type of customs legislation that the country has, to know over which actions, over which importation, exportation, or transit customs recordal will be able to take place in that country. So what products will customs look for? So we believe customs will, we don't believe, we know because it's written in the article that customs will be looking for counterfeit goods, that is in the terms of trademarks trademarks and customs recordal for trademark. We will have to look at the annex, and particularly we will have to look at Article 6 of Annex 3 to determine what constitutes a counterfeit product. So if we look at this article, it says that the reproduction, using of a mark, fixing a mark, even when you use words such as formula, type, imitation, method, constitutes a counterfeit product. that if you have suppressed or modified a trademark that was regularly applied without the authorization of an owner, that's a counterfeit product. The Article 6 also provides that if you have imitated a mark for identical products without the authorization of the owner, and there's a risk of confusion, then then it is a counterfeit product. So in those cases, for trademarks, customs recordal will be possible. We, however, have questions with regard to, because that's not extremely clear, what about maybe stickers, labels, brochures, instructions for use, warranty documents, and packaging material that bear the trademark of a counterfeit goods, but are not imported at the same time as the goods. So will these stickers, labels, etc., be considered as counterfeits for the purpose of a customs recordal? That's not clear yet, and I believe that will be an area where maybe domestic regulations, domestic laws will be able to provide further clarity, because it's not uncommon for counterfeiters. What they will do, because it reduces their risk of being caught, they will ship on one side the trademark stickers, the trademark labels. They might even ship on one side instructions for use, and then they will ship the goods separately, goods that will be unlabeled, and they will then in the country put back the goods and the sticker on the goods, the label on the goods, etc. Also, the questions of mold or matrix that are specifically designed to manufacture a good bearing an infringing trademark, will these molds or matrices be treated as counterfeit goods? We also have the question of de minimis. So what do we mean by de minimis? These are small non-commercial shipments of infringing goods. So let's say, for example, you're bringing in counterfeit goods in your luggage. You visited a country and then you came back and you bought a few counterfeit products. Can customs act against those counterfeit products that you have in your luggage? Or maybe you purchase for personal use a counterfeit product over the internet and then you have it shipped to you. Can customs act against that one infringing product that is for personal use? So that's not made clear in the Accord de Bangui, in the Bangui Agreement. And I believe, again, this is where national legislation should be able to provide greater clarity on whether customs can act, because we must not underestimate the potential damages caused by de minimis importation. Maybe now I'm talking about a traveler bringing in counterfeit product in his suitcase for his personal use after a holiday, and you're thinking, well, it's for me, I'm on holiday and I'm allowed to buy whatever I want. Or similarly to this case of saying somebody is buying online a counterfeit product and having it shipped. But if you look at how goods are being sold nowadays, especially with the boom of online shipment, not allowing customs to act against de minimis will allow a lot of counterfeit goods to enter the country. I mean, especially if you think of high value items. If every day you have one counterfeit telephone coming in through the post office, and you say customs can't act against those because these are de minimis, these are too little, it's just a personal use. Well, in a month, you have a store with 30 counterfeit phones that you can sell. So de minimis can easily grow up to fill in a complete store. De minimis importation can very quickly grow up, and it's not as benign as one might believe. One thing that we do know, however, is that parallel importation will not be subject to customs recordal at the OAPI, because the Accord de Bangui is clear that parallel importation is legal and possible, and therefore customs recordal should not be applicable on parallel importation.
Yeah, so parallel importation, that's goods that have been sold with the consent of the right holder outside of the OAPI territory and that are brought into the OAPI territory. So that's now completely legal under the new Accord de Bangui, and we are starting to see some problems with that. But okay, this goes beyond this seminar. Now, how does it work in practice? How do you have to file your application for customs action there in the OAPI countries. Again, there's a lot of question marks. One thing that we know is that the owner of an intellectual property right can apply, and Nora has already said it, but it's important to repeat. This can be the owner of a trademark, a patent, a utility model, an industrial design, artistic property, or plant variety rights. So the owner of the right can apply, and also the beneficiary of an exclusive right of exploitation, so a licensee. An exclusive licensee can also apply for customs enforcement. Now, we'll talk about the documents that need to be provided in a later stage. The question is, do you have to give a proxy? Do you have to give a proxy to an attorney who could file an application on your behalf as a right holder? That's a big question mark yet, not clarified in the European Union. All of this is regulated very tightly and very clearly. Here, this has not yet been clarified in the Accordo Bangui. I've seen your question, Emmanuel. I will answer it in a minute. Now, where do I apply for? Well, the Accordo Bangui says you can apply for customs enforcement with the customs administrations, but without giving any detail. Again, in Europe, we have a list of customs authorities that are competent for national applications, and you can also file them online nowadays in the European Union. Now, this has all not been clarified yet, and so there needs to be some further clarification before one can go ahead. One thing that has been clarified is that you have to apply for these customs measures in writing. Now, what are the documents that are required together with the application for customs actions? Well, first of all, you need to prove that you have an entitlement. So you need to provide the registration certificate of your OAPI, trademark, utility model design, and so forth. And if you are a licensee, you will also have to prove that it's an exclusive license. So you have to submit this exclusive license agreement to the customs authorities. What is in the so-called optional information, and I would highlight the importance of this information, because although the law makes this information optional, in practice, it is really the most important information. You need to provide the customs authorities with the information enabling them to recognize the counterfeit goods. What does that mean in practice? In practice, and we have done an example, we have done a training on this, which we will distribute, practical case study, which we will distribute together with this seminar. So what does this mean? It means that right holders have to inform customs, for example, who transports goods for them. So let's say you are a fashion company and you appoint one single transporter, let's say DHL or FedEx, with the shipment of all your goods. Well, this is important information, because if you tell customs that there's one exclusive transport company and you give the name of the transport company and they find your products transported by another company, well, that raises suspicions at the customs authorities. Then also, it's important to inform customs from where to where the goods are transported. So again, in our case study, we talk about this French fashion, this fictitious French fashion company that sends all its goods from one central warehouse in France out in the world. Well, that's an important piece of information for customs, because if they know that all shipments of that particular fashion house have to come from that one warehouse in France, if they intercept goods that are not coming from that one warehouse in France, well, that raises again suspicion with them. Again, you also have to inform them where the goods are going. So your appointed official licensees, for example, within the OAPI countries, that helps customs as well. Good idea also to describe the packaging of the products. And I don't necessarily mean the individual packaging. Let's say you're shipping mobile phones. To take another example, you're shipping mobile phones. Well, I'm not talking about the little carton that the consumer will see. No, because customs will not see that little carton in which you buy as a consumer your mobile phone. Customs will see the bulk packaging. So you need to describe to customs how this bulk packaging looks like, so that if they are confronted with goods, if the bulk packaging looks differently, that raises again suspicion with them. And then, of course, you need to tell customs how to recognize counterfeit goods, and many right holders have their information available, labels, sewn-in labels, hang tags, and the like, which identify the right holder, which identify the licensee who has produced them, and the like. So, there's all these little information that right holders have, and that need to be shared with customs in order for them to do their work efficiently. But meaning also that you need to be able to trust the authorities to whom you are disclosing this information, because of course this is a little bit of a trade secret. Of course, if you're disclosing how to recognize counterfeit goods, on the other hand, if this information gets in the wrong hands, you are making it easier for counterfeiters. So, there needs to be a trust between the right holders disclosing the information and the customs authorities. Then, amongst the also optional information required according to the Bangui agreement, but again, I think in practice, very important information, are the contact details of the persons who will be able to quickly determine if the goods are indeed counterfeit, yes or no, or indeed deemed to be counterfeit. So customs need to have a telephone number of somebody that they can phone up and ask them to look at the products to determine whether the right holder would consider these goods to be counterfeit. So if they're deemed to be counterfeit for the right holder. And here I answer your question, Emmanuel. It's not up to customs to determine whether the goods are counterfeit. It's not ultimately up to the right holder to determine whether they're counterfeit, but later on it's up to the court, and we will talk about that, who will ultimately decide and confirm that the goods are counterfeit. But of course, the only one who can really make this determination in the beginning is the right holder. Now, I just want to mention there is no information in the Accord de Bangui on whether right holders need to give a deposit. In some countries, a deposit is required, or whether there's fees to be paid for this application. So all this information is not in the Accord de Bangui, and also not what's the time limit for customs to deal with the application. So that's something important. In Europe, I think, if I remember correctly, it's 30 days. In Mauritius, it's much shorter. I think it's 3 or 4 days, working days. So, there's a deadline fixed. Well, it's not the case in the Bangui agreement. Then, what happens if customs identifies goods that they think are suspicious? What will they do? Well, they will notify, according to the Accord de Bangui, the applicant, that is to say the IP right holder who has filed an application for customs action, will also inform the public prosecutor and the importer. It's not clear whether the freight forwarder, for example, will be informed, and whether the exporter will be informed. In Europe, these persons are also amongst the persons that are informed. In the OAPI system is not clearly. Now, there will be a notification provided to these persons, so the applicant for the measures, the public prosecutor, and the importer. There will be a notification that the customs services have detained the goods, and according to the Accord de Bangui, the customs authorities will communicate the actual or estimated nature and quantity of the goods. So they will say, we intercepted 50 polo shirts bearing this and this trademark. So this is important information for the right holder. But it's not clear how the right holder will receive this information, whether it'll be by email, by telephone, by mail, by fax, whatever. So all of that is not clear. Now, whatever, a right holder is informed. What can the right holder then do? Probably the right holder must be able to inspect the goods, at least in the European Union and in other countries. It's clear that the right holder can inspect the goods. That's not clearly in the OAPI agreement. But of course, somebody must inspect the goods, and it's of course somebody from the right holder who must do that in order to determine whether they are indeed deemed to be infringing. Sometimes samples have to be taken. Sometimes samples can not be brought back to customs because they will be destroyed in the course of examination. I'll give you an example. If you want to examine whether a medicine does contain an active principle, well, you need to send the medicine to a laboratory, and the laboratory will have to destroy the actual medicine, take it out of the packaging, destroy the actual medicine to analyze it, whether it contains an active ingredient. Well, all of this is not clearly regulated yet in the Bangui Treaty, so there is room for some clarification there at the OAPI level.
So you have applied to customs for a customs recordal. You have provided them with the information. They have responded positively, and they have now detained goods that customs suspect to be counterfeit goods bearing your trademark. So what do you do now? So you have 10 business days if these are non-perishable products, or 3 business days for perishable goods to start legal proceedings. So that's very short, 10 business days. If you can imagine, if, for example, you would get a notification today as a right holder, if the right holder is not in the country, but the time the information maybe goes from the representative in one of the member states of your API, goes to the right holder, maybe in Europe or in the US, and then the information, the instructions come back. So 10 business days is very, very short. And as we do a lot of customs recordal, and we know that 10 business days is very, very fast. So, and 3 days is extremely fast. So you only have 10 business days or 3 days to institute legal proceedings. So the good thing is that customs shall communicate the name and addresses of the sender, the importer, the consignee of the goods, and the quantity, as Mary said, notwithstanding any question of professional secrecy, and that will be of great help to the right holder if they want to initiate legal proceedings. So you have 2 choices of legal proceedings according to the Bangui Agreement. Either you do precautionary measures. What will be termed as precautionary measures would be measures that prevent an infringing act from being committed, or that a measure that would prevent the introduction into commercial circuits of the suspected counterfeit goods. So you can initiate either have precautionary measures ordered by the competent national court, or you're going through civil or criminal proceedings against maybe the importer. And you also have, as a right holder, then to provide a guarantee for compensation in case the court thereafter recognizes that the goods were not counterfeited. So you do need to have some kind of guarantee for compensation in case the case is proved against the right holder. So 10 business days to initiate legal proceedings. One thing that has not been touched upon by the Accord de Bangui is the possibility of an out-of-court settlement. And that is something that happens quite often, actually. A right holder will accept against the payment of damages, against the abandonment of the goods by the importer, against the destruction of the goods at the cost of the importer, to not to bring judicial proceedings against the importer. So that's something that's quite common, but the Accord de Bangui does not provide for out-of-court settlement and whether there can be an agreement between the right holder and the importer that the goods be destroyed and that the importer pay damages and that there not be any legal proceedings. So other question that we have is, say now you're having a legal proceedings. So legal proceedings sometimes take a very long time, depending on the countries you're in. You can be thinking about maybe 3, 4, 5, and maybe even more years. And during that time, you have the counterfeit goods that will be restored. Because as you can imagine, until and unless there is a court decision, the goods will not be destroyed. They will remain stored. Now, the question is, and that question is still unanswered by the Accord de Bangui, is where will we be storing those goods? Do we have to store them, for example, in customs warehouse? Do we have to store them in private warehouses under the supervision of customs? Who has to pay for the storage of the goods? And that can easily become a very big issue because, as I said, if you have a court case running for 3 or 4 years, even if you're paying $20 per month, you can imagine this will grow quickly and steadily. And if you have a very big, bulky, voluminous shipment, that can easily go into the thousands of dollars spent just to store the goods. So that is a question that still needs to be answered. And I think here's again a space for domestic legislation to come in and to provide for better clarification. Also, the issue of at the end of the legal proceedings, you will have the destruction of goods that will be ordered by the court. In case, usually when the court will find that the goods are counterfeit, the court will order the destruction of the goods. There's no clear rule yet that who will be the person responsible for the destruction. Will the right holder be the one to do the destruction? Will it be under customs supervision? So that's not provided for in the Bangui Agreement, although we can likely expect that the court judgment, the decision by the court will be the one that will likely explicit a bit further how the destruction will take place.
Yeah, thank you very much. Now, before we conclude, I would like to just mention that customs also has the authority to act what is called ex officio. That means on their own initiative. So without any application for customs action, if customs finds suspicious goods, they can, at their own initiative, detain these goods and decide to inform the right holder. That's provided for by the Bangui Agreement. That is actually great news because this is something, and I'm speaking here a little bit to the customs authorities of the African countries in the OAPI who want to, build up a practice of customs enforcement. Ex officio is one strategy for customs to actively take up an anti-counterfeiting strategy by detaining suspicious shipments and informing the right holder, because once the right holder is alerted that counterfeit infringing goods are circulating in an African country, well, they need to file then an application for customs action to secure this particular shipment, which is then valid also for future cases. And that way, customs can actually build up not only intercept this one particular shipment, but build up a whole practice of customs enforcement. So I really encourage the authorities in Africa to make use of this possibility in the interest of course, also the African consumers, to eliminate counterfeit, obviously counterfeit products by detaining them ex officio on their own initiative and informing and alerting the right holder thereof. Now, the good news is also that customs cannot really be liable except if they act in bad faith. So if they do any detentions and they act in good faith, they will always be exempt of their liabilities, and that's the good news. So I think what we wanted to explain to you here today is that there is a great opportunity for right holders, because the new latest version of the Bangui Agreement has provided for the possibility of applying for customs action, seeking the help of the customs authorities when enforcing intellectual property rights. And there's a great opportunity also for the customs authorities of these OAPI countries to build up a practice in the interest of consumers, of their own economy, because as we have seen, counterfeit goods kill consumers. They are not good for the economic environment. So there's a great opportunity to take up the fight against counterfeit products through customs. The framework is there. Now we need to fill the legal framework with practice. And I really hope that we can all contribute in our way to do this. And this is what I would like to conclude on today. Thank you very much.
If I may, Marius, I think there is a question from a gentleman, Isaac, but I'm not sure I understand your question completely, Isaac. If I don't know, maybe you want to add, because I don't know if the other people might see the question as well. Isaac has asked, several products circulate in and which harm the population. How does custom arrive? Do they fight against? So I'm not too sure exactly of your question, Isaac. If you want to add in something more, maybe it will be easier for us to answer this.
So we're waiting for Isaac to clarify his question, and then afterwards, maybe Alberto has other questions.
Thank you very much, Nora, Marius, for your comprehensive presentation. And indeed, Nora, thanks for highlighting Mr. Middleton's question. Let's see if in the meantime we receive clarification from his side. Looks like, well, okay. Marius, I was wondering, Mr. Kedibe's question about how customs access counterfeiting without a final court ruling.
Yeah, so customs can only detain suspicious goods. They cannot make any determination on their own. So the customs can only detain the goods, give the right holder an opportunity to look at the goods, make the determination whether the right holder deems the goods to be infringing, and then there is the possibility for the right holder to bring this in front of the court. And in practice, many cases are undisputed. If you have clear-cut counterfeit goods, in many cases, the owner of the goods will actually agree to abandon them because, what can they do with them? And they also want to save the money for the court proceedings or criminal proceedings, because don't forget, in all OAPI countries, the infringement of trademark, for example, is a criminal offense, and there's criminal sanctions on this. And actually, the right holder, after a customs detention, can bring this in front of the criminal courts. So, all of this makes that in many cases, instead of, waiting for a judicial determination, where Nora clearly explained it's going to take a long time to have this judicial determination in practice, in many cases, there will be a settlement between the right holder and the owner of the goods, and the right holder will insist on the goods to be abandoned for destruction. The right holder will insist that the infringer pays the destruction costs, storage costs, maybe some damages as well, and undertakes not to infringe in the future. So, that's very often what happens. In Europe, as you know, we have also simplified procedures. We are far from having that in Africa. But, one way of simplifying the procedure is actually to settle it. But to answer the question, the customs doesn't make any determination on the counterfeit nature. Only the right holder can say whether he or she deems the goods to be counterfeit, and then it's ultimately up on the courts to decide.
Okay, thank you very much, Marius, for your clarification. We have received also clarification from Mr. Middleton, how customs manages to fight against fake medicines circulating in cities.
So regarding fake medicines incidents, thank you for clarification, Mr. Middleton. So it depends. So in some countries, you will have customs will have a power to actually act inside the country, inside the border. And in those countries, customs will be able to go and detain suspected counterfeit fake medicines. For example, this is the case in Mauritius. Customs can act against counterfeit products, so including fake medicines, at the border and also inside the country, in shops, in stores, in pharmacies, etc. In other countries, customs don't have the ability to do this because it's not written in the customs law. Customs powers with regard to counterfeit goods will really be limited to the borders. And in those countries, it is thus more difficult for customs to go inside. And it's not just more difficult, customs cannot go inside pharmacies, inside the country, inside shops to seize counterfeit goods. But that does not mean that there's no solution, because very often you will find that the police will be able to act against counterfeit medicines, because police have a wide range of powers, including inside in the territory where customs might not be able to act. You will also have in a lot of countries what maybe in French would be called une agence de médicaments, like a medicine agency or a pharmaceutical regulatory board or something like that, that may have powers against counterfeit medicine. Or you may have a standards organizations that will have that have the powers to seize counterfeit products, including counterfeit medicines. So inside the borders, that depends on your customs legislation, whether customs will be able to go in. But if customs can't go in, then don't hesitate to look at other organizations that might have powers over fake products, or specifically fake pharmaceutical products, fake medicines, for them to can go and seize those products inside the country.
Thank you very much for your clarification, Nora. I see a participant raised his hand. Mr. Dibril Cacho, would you like to take the floor?
Pour le moment, pas encore.
OK.
Allô?
Oui, on vous écoute, monsieur. Est-ce que vous êtes prêt, monsieur?
Vous avez une question, monsieur Cacho?
Vous pouvez la poser en français, monsieur, si vous voulez.
Oui, on parle français tous. N'ayez pas peur.
No.
No.
Believe Mr. Dibril Cacho is probably not available yet.
If he has a question later on, s'il y a une question
Yeah.
encore après, vous pouvez probablement écrire aux organisateurs qui vont nous relayer la question et on va répondre avec grand plaisir. Merci.
Oui, vous pouvez la poser dans le chat aussi ou après, je vais annoncer comment de toute façon. I see another raised hand from Mr. Kedibe. Mr. Kedibe, would you like to take the floor?
Allô, bonjour.
Bonjour, monsieur.
Oui, d'abord, merci de m'avoir donné la parole et je remercie aussi les présentateurs. C'était très brillant de la part de Marius et autres. La question que j'ai posée auparavant sur la force probante de la procédure quand on n'a pas encore la décision finale du juge, c'était tout simplement pour qu'on essaye de faire très attention dans ce genre de démarche, parce que les titres de propriété intellectuelle dans l'espace OAPI, les titres de propriété intellectuelle dans l'espace OAPI auparavant n'étaient pas donnés sur la base des examens au fond. Donc, véritablement, on avait des soucis avec des titres remis par l'OAPI parce que c'était beaucoup plus des examens formels et il n'y avait pas véritablement des examens au fond. C'est maintenant qu'avec la nouvelle loi, on peut avoir des examens substantiels qui font que on ne se retrouve pas avec des titres où on a déposé les noms descriptifs qui ont pu faire objet d'enregistrement à l'OAPI. Donc, c'est des choses qu'il faut prendre en considération. Et puis, deuxièmement, je voudrais attirer l'attention sur le fait que, bien que le centre d'arbitrage et de médiation de l'OAPI ne soit pas encore effectif, il est possible, parce que l'accord de Bangui a intégré l'arbitrage et la médiation comme mode de règlement des litiges. C'est dans l'accord, bien que ça ne soit pas encore effectif. Donc, il y a des centres d'arbitrage, soit au Cameroun, soit dans d'autres pays, des centres d'espace OAPI qui peuvent, quand ils sont saisis sur la base des règlements internes, gérer ce genre de situation. Et la dernière observation que je voudrais porter, c'est que globalement, au niveau des mesures aux frontières, il n'y a pas de dispositif express sur l'enregistrement des marques ou des titres aux frontières dans notre espace. L'accord de Bangui a présenté les procédures et autres, mais sur le plan pratique, c'est assez difficile de les mettre en œuvre parce que non seulement avec les lenteurs administratives, mais aussi au niveau même des juridictions, pour avoir un certain nombre de décisions, c'est très compliqué. Donc voilà à peu près les réalités sur le terrain. Et bien qu'on invite tout le monde à essayer d'utiliser de l'Union européenne, on peut aussi avoir des séminaires comme ça à l'attention de la douane, des magistrats et autres, pour qu'on essaye autant que faire se peut de faciliter la compréhension des aussi avoir des textes d'application pour que tout le monde soit au courant de ce qui se passe et puis qu'on essaye de le rendre le plus facile possible. Parce qu'au regard des dispositions de l'accord de Bangui, c'est difficile de les mettre en œuvre. Merci.
Oui, merci beaucoup, Monsieur Kédibé. Donc, votre dernier point, je suis tout à fait d'accord, c'est ce qu'on a dit tout au long de ce séminaire, en fait, que l'accord de Bangui prévoit un certain nombre de règles, mais qu'il est très difficile de les mettre en œuvre actuellement et pratiquement. Votre premier point, c'était de dire qu'il y a quand même un certain nombre de litiges en matière de propriété intellectuelle qui portent sur les vraies questions. Hein. Est-ce que un dessin et modèle est vraiment nouveau, par exemple? Est-ce qu'une marque est vraiment distinctive? Ça, c'est naturellement la première défense de tous les contrefacteurs et il est tout à fait clair que s'il y a une contestation, c'est en dernier ressort les cours et tribunaux qui doivent décider de la question de savoir s'il y a atteinte à un droit de propriété intellectuelle ou non. Et la première question à se poser est aussi la validité des titres. Vous avez tout à fait raison. Ceci étant dit, de ma pratique, je peux vous dire que dans 95%, voire même plus de cas, la contrefaçon est flagrante et avérée. Hein. Donc, quand vous avez des produits qui portent atteinte à une marque notoirement connue, enregistrée dans l'espace OAPI, alors il y a très peu de discussions à avoir sur le fond de l'affaire. Les produits sont des contrefaçons et c'est donc dans cet esprit-là que je disais, souvent dans ce cas, un règlement à l'amiable intervient. Vous avez aussi, à très juste titre, soulevé l'arbitrage, mais je voudrais vous dire que, en vertu de l'accord de Bangui, l'arbitrage ne permet pas de résoudre ou disons, de mettre un terme à la retenue douanière. Hein. Donc, l'accord de Bangui est clair, il faut porter ça devant une juridiction ou demander des mesures conservatoires. L'arbitrage n'est ni l'un ni l'autre. Donc, si vous souhaitez en quelque sorte maintenir la détention douanière, eh ben, l'introduction d'une demande d'arbitrage n'est pas suffisante. Hein. Je voudrais préciser ça. Merci, Monsieur Kédibé.
Okay, thank you very much, Marius. Merci, Marius. Okay, looks to me that.
Par contre, j'ai une question. Vous me permettez?
Oui, bonjour.
Bonjour. Alors, ma question est la suivante. Quelles sont les procédures pour qu'une entreprise européenne qui souhaite s'internationaliser en Afrique puisse enregistrer ses produits ou son service auprès de OAPI pour enregistrer sa marque?
Donc, ça, c'est un tout autre débat. Je veux bien vous répondre très brièvement là-dessus. Et en fait, vous faites bien de soulever le point parce que ça, c'est naturellement la première étape. Sans titre de propriété, comme on a dit dans ce séminaire, sans titre de propriété, il n'est pas possible de demander l'assistance des douanes parce que tout simplement, vous n'avez rien. Donc, la première démarche qu'une entreprise européenne qui souhaite devenir actif sur les marchés africains et plus particulièrement sur le marché ouest africain de l'OAPI, la première démarche à faire, c'est effectivement de déposer ses droits de propriété intellectuelle auprès de l'OAPI. Une entreprise européenne va devoir le faire par l'intermédiaire d'un agent à l'OAPI. Hein. Donc, il va falloir mandater un avocat, un cabinet d'avocats comme le nôtre ou comme plein d'autres pour effectivement vous assister, l'entreprise européenne, à l'enregistrement de sa marque. En général, ça va assez vite au niveau de l'OAPI. Je dirais que vous obtiendrez un enregistrement, si tout est en ordre, dans l'année, hein, même plus rapidement, d'une marque, par exemple. Donc, ça, c'est la bonne nouvelle. Mais ça, c'est un tout autre débat. Voilà, ce séminaire-là, ça porte déjà un pas plus loin, c'est-à-dire la mise en œuvre des droits.
Si je peux me permettre, Marius, de rebondir et de répondre à madame. Alors, nous avons déjà fait un séminaire sur le sujet avec l'Afrique IP, donc je vais me permettre, comme c'est un sister organization, Alberto, de mettre dans le chat un lien vers le séminaire, vers le webinaire qu'on a fait, qui s'appelle, c'est toujours en anglais, c'est Protecting Your Trademarks at the OAPI. Et donc, à travers le séminaire, vous aurez plus d'informations sur vraiment l'enregistrement de votre marque. Et vous, si vous avez des questions, n'hésitez surtout pas, vous avez notre email qui est affiché à l'écran.
Merci, Marius, Nora. Okay. Thank you, Nora.
Voilà. Le prochain webinaire qui est
Je fais de ma pub.
disponible en ligne. Oui, très bien. Et votre pub.
Right. Okay, so moving on with our webinar. Thank you, Marius, Nora, for your comprehensive presentation and for providing the answers to our questions today. I also have two important questions that I'm sure will be of interest. First of all, how effective is actually the OAPI recordal?
I would say it's very difficult to evaluate the effectiveness of the recordal yet, because as we've mentioned all along the webinar, the recordal is technically in place. There are two provisions providing for recordal, but there are still a lot of what I would call necessary information, necessary regulation to really allow the recordal to be effective and to really allow customs to act without fear. Because customs need to be guided, they need to know how to act and when to act. And we're still missing that regulations part, that being putting into practice the articles yet. And until then, we're not going to be able to really see if the OAPI recordal is effective.
Okay, thank you, Nadia. Following up on the topic, is the OAPI recordal applicable to all 17 member states?
In practice, it should be, because all the member states are part of the OAPI, and OAPI and Accord de Bangui is applicable as law in all its member states. So all 17 member states should be applying the provisions of the Accord de Bangui, including the customs recordal. This is not yet the case in practice, but it is meant to be applicable in all 17 countries.
Okay, good. Thank you very much, Nora, for your clarifications. Looking at chat, it's quiet. We have no more questions. I believe we can move on with the second part of our webinar. I would now like to give a brief introduction, some background information about the work of the Africa IP SME Helpdesk as a conclusion. Our help desk is the latest of a series of initiatives of the European Commission, implemented by the European Union Intellectual Property Office in Alicante. The help desk is part of AFRIPI, a project aiming at effectively increasing the level of protection and enforcement of intellectual property rights in Africa. We have mentioned AFRIPI during the webinar today. Very important, our help desk services are completely free of charge. Its main aim is to provide European small, medium enterprises with the necessary information to, well, first of all, protect their intellectual property, especially when expanding their activity and their business to Africa. How does this happen in practice? Well, the help desk provides knowledge, know-how, in the forms of events, for instance, and trainings like the one we are attending right now. It also organizes seminars and webinars covering a wide range of topics within the IP in Africa landscape. We also provide a helpline, completely free of charge support to EU small and medium enterprises. This means confidential, to the point, and tailored advice about intellectual property related questions concerning Africa, of course, including the countries we spoke about today, the OAPI member states. Last but not least, the helpdesk website, offering a comprehensive overview of our activities and a wide range of reading material and resources about IP in Africa, such as fact sheets, IP guides, case studies, and IP glossary news, and rather thick, frequently asked questions section. I strongly invite our audience to pay a visit to our website, and I am confident that they will find answers to their questions there. Having said this, I believe we can move on with the very last part of our webinar. And as we are approaching the end of our event, I would now like to introduce you to a partner organization whose story and services I believe might be of interest. Everyone, please meet Mrs. Nadia Sigale. Welcome, Nadia.
Thank you, Alberto.
Good morning.
Promoter. My camera.
Nadia is a promoter at the Slovenia Cameroon Business Club, a business development organization dedicated to promoting economic cooperation between the two countries through mostly trade, investment, and cultural exchanges. Welcome, Nadia, again. The floor is yours.
Thank you, Alberto. Thank you very much. I would like to thank everyone for, I don't know if you can see me.
Yes, we can.
Oh, okay. That's perfect. So I would like to thank everyone for joining us. I will just briefly present what we do, who I am, and what we do. So Slovenian Cameroon Business Club is a newly established organization which main mission is to promote trade investment between Slovenia and the rest of the Balkan region, including Austria, Italy, Croatia, Macedonia, with connection to Central Africa. Why Central Africa? Because that's our territory of operation, as we are located at the heart of Africa. So basically we cover Equatorial Guinea, Gabon, Cameroon, Chad, and Congo, where we do operations. We stimulate the companies, or we encourage companies who want to internationalize their businesses into this part of Africa. We have a lot of companies who are interested to go into the African market, but they lack the knowledge of the field. They lack the knowledge of finding the rightful partner there. And in this case, we come in to help them find the partner that they need, to find distributor for their service, to find public tenders for them if possible or if necessary, and so on. We also help with some kind of market feasibility studies with companies. So companies who have technology and who wish to implement this technology in this part of the region, the continental region, we have them carry out the market feasibility studies as well. We also do kind of like joint projects and consortium for EU project to enable this company to really make their integration into the African market and be successful. So we have a motto that we usually say that internationalization is the growth of economic, the dynamism of economic growth. So without internationalization, we all see what happened during the COVID time. Like many companies had their sales drop because they were focusing only on one single region, and the COVID gave a certain like a lesson to all companies within the European Union that is not only good to have a focus on a region. I'm talking a case of Slovenia that many companies suffered during this COVID time, and since then even the government is kind of like encouraging the company to go out of their comfort zone and internationalize their services beyond the borders of EU. And sub-Saharan Africa is also the prime target of this company. So we help you to take you there. We help you to navigate the complex environment of that marketplace. We provide you with the rightful information, the regulation, the custom information. If you have a product that you want to put on that market, we find a distributor for you, and it's for you to take advantage of the benefit that the market open. It's a market that is open to, I will call it to 300 million consumers, because just next to the markets of the Central Africa, we have the giant Nigeria, which represents about 250 million consumers, and merged with the regional market, it's up to 310 million consumers approximately. So if you are an EU company and you want to navigate into that part of the market, we stand here to connect you to the right place. And I will want to seize this opportunity also to announce our 3 events for next year. So we have quite a busy schedule next year. We have one event organized with our partners, the International Forensics Investigation Professional. With this partner, we cooperate with them in order to detect fraud companies, in order to detect non-legit persons that try to get in contact with companies in EU. So they are really our, I would say, our hand support in helping company detecting which company is a fraudster, which company is not legal, legit, or which person is not, so that company will not fall victims of scamming and many other bad intentional people that are circulating around the world. And this event will be in South Africa, and it will take place from 16th to 18th of July 2024. We invite all of you to take part in this event. I will forward to you all the information about the event. It offers great business opportunity. It's an opportunity to expose your business. There will be also some workshops and seminars that will follow. And we have the second event that will take place in Cameroon, in the capital city. It's the Digital African Fair. This is the 3rd edition with our partner Opportunities in Africa. We are inviting European delegation to this event because it also represents a great opportunity for technology and artificial intelligence sector. And this, I think, will be an opportunity also to discuss about intellectual property right, how they can secure their intellectual property right, even though they are operational on the regional market. And we have that event. This will be basically our first event of next year. It will take place in Zagreb, in Croatia, where we will discuss the business opportunities in French African region. So the French Africa, we will have two countries that we will focus our target on. So with our partner, the Ivory Coast Business Corporation, we will focus our target on Ivory Coast and on Cameroon, where we will expose the business opportunities, the investment opportunities, and we will also talk about the intellectual property rights and how this company will want to enter the African market, how they can register the trademark, how they can protect their trademark in case their trademark have been duplicated or stolen, how they can use the regulation and the European Commission IP Helpdesk in order to help them, and the OAPI to help them to get the people who did this punished. And we will also expose the universe of frauds. Why the universe of fraud? Because if you are any European company wishing to enter into the African market, you need to understand the trick of the cybersecurity, the cybercrime, because today, behind the computer sits many people. Artificial intelligence has made it that they can even duplicate a face of someone and attend a meeting to convince you more. So in this event, we will also, with our partner, the investigation professionals, we will also expose the universe of fraud and how to detect the fraudster and not be a victim of scamming. So ladies and gentlemen, thank you. And this is what we have for you next year. We look forward to seeing you in all our events. And please do not forget to drop us an email. We are on Facebook, LinkedIn, and Twitter. You can also find us on our website, SlovenianCameroonBusinessClub.com. We are there. So with just with SCBC, you will find us on all social networks. Thank you very much.
Thank you very much, Nadia. Thank you.
Thanks.
I am looking at the clock ticking right now. I believe we have come to the end of our webinar. First of all, I would like to thank once again our speakers of today, Marius, Nora, Nadia.
Thank you.
Thank you. Thank you. Thank you also goes to our audience. I take the occasion to remind everyone that any further question may be raised through our website or our social media channels. We are both on X and Facebook. Please follow us if you're interested. And with this, I officially close our event of today.